Welcome to this seminar about mastering contract negotiations and dispute differences. And here with me on stage, we have none less than 6 different jurisdictions and perspectives that we will delve into today. My name is Madeleine Thorn. I'm Deputy Secretary General and Head of Operations here at SEC Arbitration Institute. This seminar is co-organized together with the Swedish Company Lawyers Association, and the representative is here with me, Miranda.
It's so nice to be here, and we're very, very proud to be co-organizing with the SSC. The Swedish Company Lawyers Association is a Swedish association for company lawyers. It goes by the name. We're around 600 members and consisting of, I would say, across the whole Sweden, but with a focus on Stockholm, Malmö, and Gothenburg. And we're very proud to be here today, and we thank you for the opportunity to collaborate on this exciting topics.
Thank you, and thank you all for being here. And so what kind of perspectives do we have here today? Let's start with a brief introduction of the speakers and the different jurisdictions that they represent. Would you like to start briefly just mentioning your name and the organization and the jurisdiction that you represent?
Should I start? Good morning, everyone. My name is Susan Munro. As you can hear, I'm British, and I am here representing China and Hong Kong. So why am I doing that? I've lived, worked, and worked in mainland China for 30 years, and a bit of an overlap during that time with Hong Kong as well. And I speak, read and write Chinese, so I do have a few credentials.
Good morning, everyone. My name is Elke Umbeck. I'm seated in Hamburg, in Germany. I'm a dispute resolution partner of a full-service law firm, so we're, which is called Heuking. We have 8 offices throughout Germany, and we are a full-service law firm. So I'm very happy to be here. Good morning, everyone, again, and thank you for the invitation.
Thank you.
Yeah. As you mentioned, Miranda Espenes, I'm president of the Swedish Company Lawyers Association, as mentioned, and I'm also a company in-house lawyer at tech company Spotify.
Thank you, Madeleine. Thank you for having us here today. My name is Matthias Steino. I'm much less complicated than Susan. I'm from Denmark, and I'm representing Denmark. I'm a practicing attorney with a boutique law firm called Hafnia Law Firm, and we specialize in international disputes.
And I should also mention that I represent Sweden.
Morning, everyone, and thank you again for the very kind invitation. My name is Laila Sivonen. I'm with Rochier. I work as a dispute resolution partner with Rochier. You may know the firm. We have offices in Sweden and in Finland, but today I'm here to represent Finland and talk from the Finnish perspective.
Thank you very much all. We have very interesting discussions ahead of us, as you can all tell. And let's start with a Nordic perspective, and more precisely Denmark. So I turn to you, Matthias, and you have told me that when you were little and you grew up in the countryside, you thought that you would become a dairy farmer. But now, as you mentioned, you're partner with Hafnia Law Firm in Copenhagen. And would you like to share with us a general overview of dispute resolution in Denmark?
Thank you, Madeleine. I certainly will. I think I've brought with me here today an audacious theory on the roots of the success of Swedish arbitration that I'll share with you. And that will hopefully also give a perspective on the differences between Sweden and Denmark in terms of arbitration. And that turns around two, you might say, unlikely heroes of arbitration. The one is King Christian V of Denmark, and the other is Pippi Longstocking. Now, let's turn to Christian first. He was a king in Denmark in the 17th century, and during his reign, he introduced a comprehensive set of laws which contained the first rule on arbitration introduced in Danish law. So it was just a simple rule, but it denoted the demarcations between the courts and arbitration. And if you choose arbitration, you exclude the courts. And for centuries, it was the rule that basically from which arbitration grew and which defined to what extent the courts could interfere with arbitration, pretty much in the same manner that we see in the model law today, but it was just in a less complex legal regime. So he was the forefather of arbitration in Denmark, and thus the hero of arbitration in that perspective. Also for Norway, because it was the twin kingdoms of Norway and Denmark at the time, so this rule was also introduced there. Fast forward to 1972, we got our first Arbitration Act. It was still not what you would today deem a comprehensive arbitration rule set. It was a brief act of 6-7 provisions or so. And that was then the governing laws on arbitration until 2006, when Denmark finally became a model law country, and we enacted what is a modern rule set governing arbitration. The rules are still in place today with a few amendments, but it very much reflects modern international regulation around arbitration. So you can say that Denmark has been more of a marathon runner and not a sprinter when it comes to arbitration. It's been a slow, gradual development, and it's basically been rooted in domestic traditions. Enter the scene, Pippi Longstocking. What does she have to do with arbitration? If we go back some 50 years almost, there was a pivotal year for Sweden in terms of its role in international arbitration, namely when the USSR and US made a trade treaty which stipulated that disputes should be governed or have their seat in Stockholm. And so that sort of catapulted Stockholm into the international scene. I know that the SEC is much older than that, and I'm not trying to say that there was no arbitration before, but certainly that was an important step forward, one big leap for Swedish arbitration. And you might ask yourself then, why would Moscow accept Stockholm to be the arbitration venue for disputes? So it was the East and West, and of course Sweden was part of the West. And you might say, well, how did that come about? Would there be other venues that would be more suitable for both parties? And here I think Pippi Longstocking may play a small role. Pippi Longstocking was written in the late 1940s, but was translated into Russian and published in Russia in 1968. And the expressions that come out of Pippi Longstocking of humanism, and basically also a concept of neutrality. She was read everywhere in the East and in the West. And Astrid Lindgren was very influential in the USSR as well. And I think these timeless concepts of humanism, of coming of age, and things that are expressed, and also Pippi Longstocking against the establishment, all of that at least was a huge soft power that gave Astrid Lindgren a lot of that sort of power in the USSR, and might just, and that's where my audacious theory comes into play, is that the superpowers of Pippi Longstocking then meant and transformed into the superpowers of Swedish arbitration, because suddenly this was a glowing hub of international arbitration, and you can almost hear her saying, I don't know anything about arbitration, so surely I can do that. And so why am I bringing all this up? I think I'm bringing it up because Sweden is a sprinter, and Sweden was suddenly catapulted into the international arbitration world and became a hub like London, Paris, Singapore, Hong Kong. And Denmark has been much more of a domestic tradition. It works very well in Denmark with arbitration. We've got a modern rule set, but I think a lot of the whole arbitration community has trailing past or behind Stockholm for many years, and a lot of international concepts have been introduced in Denmark much later. So that was my small cautionary tale introducing the differences between Sweden and Denmark. Thank you.
Thank you very much. And digging a bit more into detail and perhaps to today's practice, would you like to share anything about, for example, taking of evidence? Are there any particularities that we'd like to point out in Denmark?
Yeah, sure. So again, picking up a bit on the differences, definitely, am I going through here? Yeah. Definitely Denmark is now utilizing modern concepts of arbitration, such as witness statements and party-appointed experts. That used to be just going back 15, 20 years, we were much more rooted in a tradition similar to the Danish state court litigation practices, that you would have hearing, or you would hear witnesses in chief, so you wouldn't have any written witness statements. And I think that's where Denmark is now, is that possibly for domestic arbitrations, it's still to a great extent the norm that you just have examination in chief. You don't work with written witness statements, but that in international arbitration seated in Denmark, definitely written witness statements is nowadays the norm. And I think we've seen the same development in terms of expert reports, where the traditional sort of system with expert reports is also rooted in the state court litigation, where the courts would appoint the experts, whereas the continental international tradition is that we're in arbitration, each party appoint their experts, you present them, and you may have the experts also convene beforehand, discuss concepts. And that is a feature of Danish international arbitration, but I think we're standing still to some extent in between traditional methods and modern methods. So even in international arbitrations in Denmark, you might still come across situations where you don't have written witness statements, or you don't have party-appointed experts. So that's probably one of the places where we see development, and where there's still some way to go in order to have conformity with international norms.
That's very interesting. And what would you say in general would be the preferred, for businesses in general in Denmark, what would be the preferred form of dispute resolution?
Most definitely arbitration. That has also changed a lot, I would say. But I think some people are actually have the opinion that there's too few disputes that go to the courts, because then you don't have sort of the publicity. Not that you need to know the disputes between private parties, but you perhaps to some extent lack publicized precedents. And so what is actually the current state of law in terms of interpretation of share purchase agreements in M&A disputes? Well, it's all dealt with in arbitration, so the courts have given no directions in disputes of that nature. But certainly it's not going to change, and I'm not advocating here that it should change. I'm just stating that's how it is.
Thank you very much. We will continue with the Finnish perspective, Laila. When you were little, you wanted to become a private detective. And do you see any comparisons between that childhood dream of yours and what you're doing today?
Thanks, I do. I mean, I read my Nancy Drews and watched all the detective series, and I do see a lot of similarities, because in addition to sort of dispute resolution, I also work with compliance and investigations. And both disputes and investigations, you sort of the first thing you do is try to sort of sort out what has happened and what is the evidence to support this, and so on. So yes, it is a dream come true. It is a dream come true. And I do see a lot of similarities.
That's great. And would you also like to share with us a perspective, an overview of the Finnish perspective when it comes to dispute resolution?
Yeah, sure. A very sort of broad question, and maybe I start with sort of some background and context, because we at Rochier, every 2 or 3 years, we conduct a market survey into Nordic companies' dispute resolution preferences. We've done this since 2014, and now that we have done this for many, many years, it does give us good insight into the developments. And what we can see, the latest edition is from 2024. By the way, I have a copy with me. Happy to share a link afterwards if you're interested. The latest edition shows that the clear preference for arbitration that Finnish companies have had already earlier, it has become even stronger. I think Finns appreciate the private nature of arbitration. As you know, we Finns, we're very sort of, private. We like to keep our distance, and I think this has something to do with sort of how much we appreciate the private nature, the non-public nature of arbitration as well. We're also very pragmatic. And there I also think that the flexibility that arbitration comes with is something that Finnish companies really, really appreciate. And then there's the speed, because unfortunately, in particular after COVID, the Finnish courts, especially the biggest courts, they are just overly burdened with family matters, with criminal matters. So the commercial disputes, the handling of those tends to be very, very slow. So for this reason as well, Finnish companies continue to have a strong preference for arbitration.
That's very interesting. And the caseload for the general course is something that we see in Sweden, of course, as well.
Yeah.
And so you mentioned that there is a shift towards arbitration, and I know from your report that in 2014 there was a preference for litigation about 11%, but that dropped to 5% in 2024. So it's definitely an impressive decrease in preference when it comes to litigation. So then with an increased shift to arbitration, what would you say the trends are in terms of institutional or ad hoc?
I would say definitely institutional. So we see very little ad hoc arbitrations. Those are mostly related to old contracts. I just had an ad hoc arbitration, a domestic one, but that related to a contract that was from 2010. So I think the only context where we see ad hoc arbitrations nowadays is sort of with disputes that relate to very old contracts. So definitely there is a strong preference for institutional arbitration. And when we launched the latest edition, you were there for the launch event, and we talked about the Swedish triumph, because what the survey also showed is that all sort of Nordic companies, if they cannot choose their own domestic institute or their own laws, they prefer Swedish law and the SEC. Congratulations. So that was the Swedish triumph that we talked about in the launch event. And I think that goes very much for the Finnish companies. So if you're in contract negotiations with Finnish companies, I think you will have sort of no trouble referring to SEC and Swedish law. I think in general, Finns feel that Swedish law is very familiar to them, and of course very similar to Finnish laws in many ways. And they know that SEC is a great institution and appreciate it a lot. So yeah.
And Matthias was mentioning the differences when it comes to domestic and international arbitration, and especially when it comes to taking of evidence, for example. Is that something that you see that there are differences in Finland as well?
Yeah, not too much. I mean, in domestic arbitration, we rarely work with written witness statements, and I guess that is probably the one big difference. Other than that, not too many great differences, I would say. If it's a domestic proceeding, then it tends to be sort of closer to what you would expect to see in the courts, in the sense of just how the procedure is run. But no major differences, I would say.
And what would you say in terms of settlements? Is this something that is occurring at all? Is it, or are there any trends that you can discern when it comes to settlement rates in Finland?
Yeah, sure. I would say that Finns, and according to the survey as well, many disputes get settled before there is an actual award. And I think Finnish companies do have a great preference for sort of trying to settle. Mediation is still, I think we have been talking about it for more than 10 years, that mediation is coming. Now it's coming. And still, I think in the conversations with Finnish companies, there are only a few who have their sort of own personal experience from mediation. And there is this great hesitance towards mediation. I think it has something to do with the fact that the company representatives have to be really involved, and they take their time and sort of really invest in the mediation, not only in monetary terms, but also sort of be there present. And for many, it is still something that is not too familiar. So I do see a sort of, I'm still optimistic that mediation will become a bigger thing, and would be interesting to hear from the Swedish perspective as well, whether the same goes for Sweden. But still, in Finland, it's not used too often.
No, that's very interesting, and that is actually a focus area that we have here at the SSC, because we do see all the potential in mediation, that you can resolve a dispute within 1 or 2 mediation days. That's what the statistics show. But we see that it's not used as much as it could be, and especially now with the trends in Sweden, and I will soon hand over the word to Miranda to expand on the Swedish perspective, but that the disputes become more complex, they take more time, and they're more costly. That's at least some criticism that we've heard for some time. And we are, of course, at the SEC trying to see how we can counter that. And one thing I definitely think is mediation, that you can at least consider in more circumstances and more contracts than perhaps you do today. That will be the segue then over to, thank you so much, Laila, and we will continue with Miranda and sharing the overview of the Swedish perspective. But first, you had several childhood dreams, but a recurring one was to become a journalist. Do you see any journalism in the work that you do today?
It's a good question. I may not write front page headlines, but I think like the curiosity never went away, in a sense. So I would definitely say that translates to what I do today. Being in-house at a big tech company definitely comes with a lot of pros with being a curious person. And I mean, writing, that's still what a lot of lawyers do, even if the buzz around AI may indicate we're prompting more than we're writing. But I do enjoy reading and writing, and that's still, I would say, around. So I can see the translations in a way.
And you have a background in dispute resolution and are now working as in-house. So what is your Swedish perspective on dispute resolution, given that background and what you're doing currently?
To your point, Madeleine, going in-house from being in a dispute resolutions group, I would say really put the focus on, I think, what... I wouldn't say my main interests, but when I speak to other company lawyers, it's a lot of focus on settlements. So I think I may just start there, which is a bit unconventional when speaking about arbitration. But it's an interesting point, I think, with the Swedish culture, if you will, in general. And Matthias has highlighted a lot of interesting, like the background and the context. So I'll have a very practical oriented perspective to start off. But in terms of settlements in Sweden, and this goes also for, I would say, general courts, it's a very settlement oriented or positive towards settlements in Sweden. In Sweden, and this is probably very similar to Denmark and Finland, which are big similarities in arbitration law and other laws with Finland, for example. But settlements are, of course, allowed, and up till a fairly late stage as well. And we recently did a small poll in the Swedish Company Lawyers Association, just asking about, for example, the attitudes towards settlements and how the in-house company lawyer would approach like a dispute and what the expectations would be. And not surprisingly, in-house lawyers are very positive towards settlements. I think there's absolutely situations where the company or the in-house lawyer is very interested in arguing the case or getting the case processed, but it's a very, very positive attitude towards settlements in general. And we discussed this before, Madeleine and I as well, in terms of how the arbitrator, like how the judge and the judges would view a settlement in relation to maybe what the parties' expectations are. So that would be interesting to discuss as well, and to see if there's any differences between like attitudes and feelings that you experience that the clients have. But from Swedish company lawyers, it's a big expectation to at least get the question raised and in a way not exclude the possibility to have something settled even at a late stage. And when we asked other questions about, for example, ad hoc versus institutional, because we thought that was interesting to know, and taking evidence, there's a fair share of in-house lawyers that never see the case go thus far. They say, well, that's an interesting question, but we haven't really seen our cases go to that front or that end. We are very focused on settling the cases where we can, even if it goes to like the hearings. That was a bit interesting to me, also with the background in dispute resolution, to actually hear that strong preference for settling cases.
That's very interesting indeed. And how do you see that positive interaction with settlements, and that the company lawyers are very positive to settle and to even at a later stage, but that they also many times don't even see taking of evidence because you don't get that far. Do you see that that's reflected already in the contract drafting?
I would say ideally it would be seen more, to the point of, for example, mediation. That's a very interesting opportunity. I think the insights and the proactiveness could definitely increase. There's a fair share of company lawyers, of course, with contract libraries containing mediation clauses in the arbitration clause. But I think the reality is that there's much we could do, maybe within the Company Lawyers Association or in general, to just, I guess, share the knowledge as well about how much you can actually do in proactiveness to maybe control more, to have those opportunities and to set expectations with the counterparty. We, of course, have the SSC standard clauses that we, on the company lawyer side as well, often see incorporated when we perhaps get agreements from a counterparty, another commercial party. But I would say it's rarely seen with mediation clauses, which is an interesting case because looking at the commercial relations, maybe that could be very favorable to have a mediation clause and to set that expectation already in the at the negotiation table.
For sure, we do see that even though it's of course possible to agree at a later stage about mediation or even arbitration or the SSC clauses when there is a dispute, it's always easier to agree when you're drafting the contract and when you agree on the other things in your corporation rather than deciding on how to fight when there's already a dispute. So that's definitely something we would recommend as well to look into and think about beforehand. Is that something that you see, that you spend time on strategic planning of the contract in terms of dispute resolution?
I would say with especially counterparties that you come across more than once, absolutely there's a discussion. And I would say to the point that's already been made that in the Nordics it's fairly, I wouldn't say straightforward, but suggesting Swedish law and SSC as a forum for arbitration, I would say is quite standard, doesn't really raise any eyebrows. But then again, being a perhaps big company and negotiating with parties all over Europe or all over the world, it can oftentimes be an interesting case to decide on. And that's also, I would say, the reality of negotiations between commercial parties, that the counterparty could be more or less interested in deep diving into those questions. And it's oftentimes, my feeling is it's a big advantage to just suggest the first contract draft and then get your opinion in on what form it should be. So I would say that's also reflective in probably the contract processes at companies as well, where big companies tend to automate a lot and say, these are our standard terms. This is what we expect from perhaps our providers, also in terms of forum.
Do you anchor your own preference?
Exactly.
And now, thank you so much. We have had the Nordic perspectives. Any thoughts or contrasts that you see or that you would like to bring up from what you've heard from the others in the panel? We will shortly move on to this side and to hear other jurisdictions as well. But we can see from the Nordic perspective that there are some similarities, although some differences also when it comes to preference of dispute resolution in terms of, for example, mediation settlement seem to be something that's preferred, but also that there are more similarities when it comes to domestic disputes and also being handled in a more court-like way. That's at least what I see from there.
Yeah. Maybe just a real life reflection on what you said, because being a dispute resolution lawyer in a big law firm, I often get those late night calls or Teams chat messages from my M&A colleagues that, is it fine to have English law as the governing law and then the seat in Sweden and then the Finnish institute, and then starts a late night discussion as to, yeah, the governing law is one thing, the seat is another thing, and then the institute is a third thing. And it is actually perfectly fine to mix, but it's typically those late night conversations. So that tells me something about where the priorities lie in those transaction negotiation. And I don't know if this is something that you recognize.
You start asking, why are we doing this? Are we tailoring, or is it?
Yeah.
Yeah, the dispute resolution clause is called the midnight clause for a reason.
Yes.
So, but this is a really good point, and I'm sure you're aware, but under the SEC arbitration rules is of course no problem, and this is also what we see in our cases, that we can have seat from all over the world. There can be a governing law from any jurisdiction, so that's absolutely possible, and it can be both from civil law and common law jurisdictions. Yes.
Yeah, no, I was just going to say that I echo that for Danish companies entering into contracts is always very easy to agree on dispute resolution in Stockholm, and for Danish companies certainly that's an attractive forum. It's close geographically, but also culturally, and in many situations, and perhaps there's a difference there between Sweden and Denmark. It might be difficult to convince your counterparty to have arbitration in Copenhagen, because it's not a dot on the world map in that sense, and it would then just be perceived as the home turf. Whereas possibly, even if you're a Swedish company and you then propose SEC arbitration, it's hard to argue that there would be anything wrong with that. And then I also had a reflection on the settlements and clauses with multi-tier dispute resolutions, including mediation. That I've had some mediation experience, not a lot. It's always worked out quite well, but I also see these clauses being used tactically in a lot of arbitrations. As whenever a party commences arbitration, the other party comes and says, "Oh, you can't commence arbitration now. There's no jurisdiction because you haven't gone through the ladder," and it's just occurring in so many arbitrations. Of course, that's something that could go into the drafting actually to make it better in that sense. But it's actually goes the other way around often. That it, rather than facilitating settlement, it just becomes another weapon.
And there's definitely a risk, and this is something that we have taken care of in the SEC mediation rules, so rest assured they will not be a problem. In the SEC rules, we have specifically stated that even if you have a mediation clause, given that mediation is based on consent and that both parties are active in settlement discussions, that's a prerequisite for mediation really. It's not a bar to initiating arbitration. If you have an arbitration clause referring to the SEC, you can go straight to that. So that's taken care of, but that's definitely something that could happen. And it's of course up to the parties. If you wish to regulate it any other way, the parties are free to do so. But if there are no other explicit statement, then this is how we will treat it, the SEC rules. Thank you. And let's continue then and shift perspective completely from more civil law with international practice influences to Hong Kong and common law. And to Susan, you were drawn as a teenager to theater acting and theater directing, and we can definitely say, I can definitely see some similarities, I would say, to perhaps a different type of acting when it comes to arbitration, and as an arbitrator to direct the scene in the hearings. So it'll be very interesting to hear your perspectives, and you will actually have two slots because you will have both Hong Kong and mainland China perspectives, which are very different. But let's start with the Hong Kong overview of that jurisdiction and how arbitration and dispute resolution works there.
Okay, thank you, Madeleine. I should say that I don't think theatre directing has anything to do with what I do. The drama of the arbitration hearing is a poor substitute at best. So, yeah, I did become a barrister, and you could argue that they are more theatrical, perhaps, but no. I calmed down and became a lawyer. As Madeleine mentioned, I'm talking about two different jurisdictions, two fundamentally different jurisdictions. But I'm going to take, given that there's only 5 minutes for each, I'm going to take this approach. I'm going to provide an overview of the issues in each jurisdiction as they might occur to you from reading international media, speak very briefly on contracting, and then make a few comments on dispute resolution in each place. It's impossible to cover all the ground because these are very complex jurisdictions. I'll do my best, but you are bound to have challenges probably and questions, and I'm happy to try and answer those. So the first, to focus on Hong Kong, and Hong Kong is in a very critical position, you might say now. The importance of the Hong Kong legal system and its, in particular, its judiciary to its current resilience cannot be underestimated. So Hong Kong operates a common law system, and that is a continuation of the system established by the UK before the handing back of the territory to the People's Republic of China in 1997. This means that China, which operates a civil law jurisdiction, as a civil law jurisdiction, also operates and supports a common law jurisdiction within its borders, which is an interesting concept. And I emphasize the word support there because nowadays we do see mainland China supporting a separate common law jurisdiction in Hong Kong. The basic law, which provides for the legal harmonization of mainland China and the Hong Kong Special Administrative Region, stipulates that Hong Kong is self-governing and has its own laws, but that external matters, i.e. matters that are external to the sovereign territory of the People's Republic of China, are handled by the government in Beijing. So for a while after 1997, this legal separateness, or separation, not exactly, served Hong Kong quite well because it was able to maintain a similar stance, commercially at least, to that that it had held before 1997. However, recently, and primarily in response to geopolitical issues, and in particular the situation between the US and mainland China, Hong Kong is now seen to be Chinese full stop, even though it's very different to mainland China. So Hong Kong is coping with this quite well, I would say, and they're being very pragmatic, as they are, and they're relying heavily on the strength of their legal system and their dispute resolution system, and they are seeking to develop new markets that really walk around the issue, with taking into account that they are, of course, part of the People's Republic of China. So what does that mean for commercial contracting in Hong Kong? So essentially nothing has changed in my view, and I'm old enough to straddle both regimes, if you like. So Hong Kong is still the preeminent financial center in Asia, and global financial institutions have complete freedom to operate, and they are relying heavily on Hong Kong law and the judiciary, the rule of law, in order to do that. So Hong Kong parties in Hong Kong, and this happens every day, are comfortable negotiating contracts governed by New York law, English law, Delaware law, Hong Kong law, and interestingly, PRC law. So they're one of the few places in the world, I think, where you get complete fluency in so many different legal systems. And that means there are a lot of lawyers still there. In relation to Hong Kong judgments and Hong Kong arbitral awards, they can still be, without issue as far as we can see, enforced outside of mainland China, outside of Hong Kong. So we haven't seen, for example, political pushback in terms of enforcing arbitral awards in the US, which is interesting. Another important feature of Hong Kong is that it's outside the scope of the mainland economic sanctions blocking statute. You'll be familiar with this from the EU. The EU has a blocking statute, which is sort of operated passively with the US. The Chinese blocking statute in relation to US economic sanctions is very aggressive, but it doesn't apply in Hong Kong. So in Hong Kong, you have a situation where banks can complete their compliance obligations with regard to the US in relation to economic sanctions, but also they can transact with Russian companies, provided that they comply with all the other regulations that govern them. So that also gives Hong Kong somewhat a unique position. The Hong Kong International Arbitration Centre handles disputes with Russian parties, and they've entered into special understandings, one might say, with banks in order to how they're funded and how they receive payments. Picking up on the word funding, Hong Kong is a jurisdiction that works well with third-party funders for arbitration and litigation. Well, actually, not litigation yet, but arbitration. So finally, a few words on dispute resolution. Hong Kong has its own arbitration law, the Hong Kong Arbitration Ordinance, which for many years has been cutting edge. It's a really robust arbitral regime. And it's updated fairly regularly, taking into account developments in dispute resolution internationally. The most recent update was in 2022. And Hong Kong benefits from all those international arbitration practitioners that still support Hong Kong as an arbitral centre. Hong Kong's got the other point I'd like to make is that the ICC has a functioning secretariat in Hong Kong, as does CTAC, the big Chinese arbitral institution. Now, the HKIC, ICC, and CTAC, all when they operate out of Hong Kong, have a unique advantage in that Hong Kong is the only jurisdiction globally, and this includes Singapore, that is able to use the Hong Kong court and the PRC court to apply for interim relief in the course of a cross-border international arbitration. So, for example, you can freeze assets in mainland China if you're a foreign party, and provided there's a proper legal basis to do so. And you can't do that outside of mainland China normally. And this has had a big effect. It's been used a lot by parties arbitrating in Hong Kong. And it does result in settlements because, of course, if you can seize an asset, you've got a lot of leverage, so on and so forth. The other question you may have is about the New York Convention. Hong Kong used to be a party to the New York Convention in its own right. It's now part of mainland China. So how do you enforce a Hong Kong award, which is in technically a different legal jurisdiction in mainland China? You can't do it under the New York Convention. And to resolve that issue, there's a special arrangement so that Hong Kong awards are enforced in the same way. They mimic the New York Convention arrangements for the mainland. And that includes something that is very important in relation to the mainland. It includes something that was established in 1995 in the mainland, whereby the Supreme Court reviews any failure to enforce foreign arbitral awards. Hong Kong arbitral awards are also reviewed by the Supreme Court, which prevents a lot of the issues with local protectionism and so on. The only problem with that is it takes a hell of a long time. But I'm going to stop there.
Any thoughts or comments? Yes, please, Matthias.
Yeah, it comes to my mind that, well, one of the features, if I may say so, that I very much dislike about English arbitration is,
Okay.
I think it's section 96 or something, the possible appeal to the courts of arbitration cases in matters where there's an error in law. Is that also, does a similar rule exist in Hong Kong?
The Arbitration Act is very different to the Arbitration Ordinance. The Arbitration Ordinance tracks the model law very closely. The Arbitration Act, in my view, does not track the model law, certainly not as closely. So we don't have that. Now, having said that, people do try it on. And we get a lot more random applications to challenge arbitration awards these days, but the courts are very strong, hold the line. They would not entertain that unless it tips over into public policy. Yeah. And then maybe but they're very supportive of arbitration. And I think there's also in the Hong Kong arbitration environment an awareness that you have to be very careful about ad hoc arbitration, which is where these issues tend to arise. Often the ICC, for example, although it's not supposed to step into legal matters, can indicate if an arbitration tribunal is going very off track. So these issues tend to arise with ad hoc arbitration. And I think there's except for specialized ad hoc arbitrations, generally for cross-border arbitration, you don't tend to use ad hoc in Hong Kong.
Thank you. We will now turn to not the final and last perspective, because we are going back to you, Susan, shortly. But I'll now turn to you, Elke, and the German perspective. But before doing so, you dreamed of becoming an archaeologist when you were little, and you said that you still like digging for rare pieces of the puzzle and finding the truth. So perhaps Susan didn't agree with me that there were similarities. What do you say? Are you living your childhood dream today?
First of all, there's a huge difference. I spent less time outside and in the nature than I would like to. But anyhow, yes, there are similarities. I still like digging for tiny pieces of a bigger puzzle and bringing them together and find the truth or the narrative behind the whole dispute. Yeah.
That's interesting. And then please share with us an overview of the landscape in Germany when it comes to dispute resolution.
Yeah, I'm happy to do that. Actually, I feel very Nordic this morning. I can mirror a lot of things having said today, and at the same time, I feel like
You feel Chinese?
Yeah, from a civil law perspective, definitely, because actually Germany is a civil law country, and I feel like bridging here the different perspectives. Actually, Germany has a very long arbitration history. So I think, from what I know, I haven't prepared that well like Matthias did, but there is a common history with the Nordic countries as well. We commerciants engaged in the Hanseatic League, and from there on, they had their uniform rules and uniform law in a way, at least for sales law, and they had their own jurisdiction as well. So that is something we share, this history, and well, then it developed, and in Germany, Germany had its first arbitration law in 1887. I think very similar to Sweden, first codification. So that is was taken up in the Civil Procedure Code in 1887, and then we had a very huge reform in the early 90s, and Germany picked up the UNCITRAL model law. Now there is a draft act pending, and it should have been enacted last year, and we hope it will be enacted this year maybe, with some tiny reforms. It's not so severe, but Germany has established commercial courts in the different regions, and these commercial courts will also handle any application for setting aside awards or and supporting the arbitrations. So Germany is very arbitration friendly. So usually awards are upheld. In very rare cases, you will find that there's something against the ordre public, or rare cases where there are problems of the procedure. What else? Specifics of German arbitration standards, because we are looking for best practices and what we maybe can adopt or learn from each other also. First, I think there's a difference between domestic arbitration and international arbitration, that has been mentioned before. So the tendency to adopt court traditions more also for arbitration proceedings is that holds true for domestic arbitration. So usually we will not have cross-examination in domestic arbitrations. That's not part of our own judicial tradition. We don't have disclosure proceedings, so that is also declined in domestic arbitrations. Witness examination usually is run by the arbitrators. That can vary. And everything depends from actually the parties, because that is discussed during the case management conference, and usually arbitrators are quite open to what the parties actually wish and expect. For international arbitrations, we are quite used to the international standards. So written statements is standard. Oftentimes, you will have disclosure proceedings. You will have cross-examination. So that is followed. A special feature which I would like to mention is that settlement is rooted in our civil proceedings, in the state court proceedings, but as well in our domestic arbitration landscape. So there's in our, actually the companies at the end, they expect an efficient dispute resolution. That is what they wish for. Of course, they are also interested in a good outcome, for sure. But efficient dispute resolution, as you mentioned, oftentimes looks for or is facilitated by settlements. So how German arbitrators oftentimes like to approach that. How do they actually can foster a settlement? It's not. You need a certain technique to prepare the parties to come to a settlement, because apparently they could not settle the case beforehand. So what German arbitrators offer is to have designed settlement arbitration hearing, and on that only if the parties wish so. And I noticed that there's a lot of skepticism around that issue. Yeah, how should that work, and is that fair to do that? So the arbitrators offer to share a preliminary view, which is preliminary, and that has to be emphasized all through the whole hearing. It is preliminary. It is not that we have already taken our position that it is final. It's just a spotlight on where we stand now, and maybe it can help you to see and get a better overview of the whole puzzle which we have in front of us. Sharing this preliminary view just as an overview of the different topics, the evidence which needs to be taken, and that is done. The whole preliminary views conference is done at a very, very early stage. So by definition, it is preliminary, because before evidence taking. So it just to mention, well, these are the issues at stake. There are certain legal issues, but there's definitely also some gray zone in the facts. Evidence has to be taken. There's a risk here, there's a risk there. And that is more or less the perspective which the arbitral tribunal can take. Sometimes they also say, well, there are certain issues where we are completely in the dark. We cannot share any preliminary view because it's just unclear to us. But certain things we have understood, and these are the issues at stake, at least. And
That's
that
very interesting. And can I
sometimes
just
help.
Yeah. So is that I'm just comparing to the Swedish perspective, which I can share in more detail briefly. But just a question: in your experience, has it ever been problematic, this sharing of the preliminary view, say, if there is a subsequent challenge proceeding or so?
From domestic proceeding, not at all. I realize that it is very, very helpful to make that very, very clear to the parties what you are aiming for. And if you have German counsel at least, then they will know, and they can also explain that to the parties. So I'm not aware of, I mean, I know there's a case decided here in Sweden, which I think is a little bit different, because there the arbitral tribunal actually did not share a preliminary view but a final view, and they put that in writing. Normally we don't do that in writing. Here in that case they put that in writing, and then they deferred from that without notifying the parties. That is obviously problematic, and it would have been in Germany as well. But other than that, I'm not aware of. I'm aware of skepticism, because it seems to be, for us it's a very normal thing to do. But I realize that for lawyers from other jurisdictions, it's very awkward to share at a very preliminary stage a preliminary view, because it. But you must be aware that it's not the end of the story. It's just a very transparent, open sharing of views, and it does not mean that this is cut in stone.
Yeah, that's very interesting, and it makes me think of different mediation styles. And in Sweden, we see when you have mediation, but then typically a separate mediator that will only mediate and not determine the case on the merits. Then our tradition in Sweden is to have a facilitative mediation, meaning that you would not express any view on the outcome that you would decide on if you were to decide a case, but rather give the parties the opportunity by asking them questions to find their own solution. But we see that there has been some criticism to this approach, and saying that sometimes it's not enough to help the parties to really reach a settlement. Sometimes, and under certain circumstances, you would need to have an indication similar to the preliminary view. If I were to decide this case, the mediator can say, I would say this is what I see as weaknesses or strengths in your cases, and this is what you could consider to move forward and potentially find a settlement in the more evaluative mediation style. So that's definitely something that you can do, but we see typically in Sweden is more of that the arbitrators are cautious to even bring up, as you mentioned, that it can be valuable for the arbitrators to bring up, have you had settlement discussions, is it something that you've considered? But we typically hear the point of view that arbitrators should be very careful with that in Sweden. But from our side, from the SSC's point of view, it's absolutely possible under our rules to initiate at least ask the parties, have you had settlement discussions? There's nothing that we see as problematic under our rules. And of course, our rules are adapted to any jurisdiction, any governing law. But that is something that you could bring up, but it could be the problem of neutrality and not taking a stance too early in the process. So it's very interesting hearing the German perspective in that regard, that at least when it's clearly communicated that it is a preliminary view, this is something that can help the parties reach a settlement at an earlier stage.
And if not, it at least helps the counsel to better shape their arguments, because they realize, oh, well, there's a problem and I need to focus more on that specific aspect, and I need to explain that better, so in order to convince the arbitral tribunal. So that can...
If I may add there, I mean, I think it makes you, it's very different as well from what we do in Denmark, and also what I understand internationally, that arbitrators would be super reluctant to share their views early on. But when you think about it, if you're counsel to a client, you know that when the arbitrators are reading the material, they form a view. So would you rather know that or not know that? I think obviously you would want to know it, because then you can work on it, rather than if you stay oblivious to that, then you can't really know where to make your case. So I think I can see the appeal of it, even if I still have my concerns over it. Yeah.
That's very interesting. Thank you for sharing it. And we'll go back to Susan and hear more. You've already mentioned a couple of characteristics when it comes to mainland China and dispute resolution, but would you like to perhaps expand on that a bit?
Sure. And I apologize if this is a little bit like a lecture again. The other point I should make is that I'm here, not only am I British talking about China, I represent a US law firm, K&L Gates, from Hong Kong and Beijing. So, as Madeleine has pointed out, the mainland China has already been mentioned. I'm going to provide a little bit more detail. Again, it's impossible to cover all the ground because it's so complex. And I wanted to note in passing the role of the SEC historically in cross-border arbitrations involving mainland China. And of course, this was early on, and it tracked, I'm sure, the US-USSR agreement that specified Stockholm, and China at that stage was very much following the USSR in what it did in that early stage. It's very different now. So Stockholm, if you like, has this history of China-related disputes. And there's still, I can confirm, in mainland China, there's a memory of that and an interest in that. So turning more generally to the PRC, I'm going to wow you with some statistics. The PRC is a prolific generator of disputes, the majority of which are domestic. The numbers represent the huge legal demographics in mainland China, which I think dwarf every other legal jurisdiction globally. I don't think there's anything that can come, any jurisdiction that can come at all close to mainland China in terms of the volume of arbitrations. It's a little bit difficult to get accurate statistics, but here we go. In 2019, arbitration commissions in China accepted 486,955 cases, with a total amount in dispute of approximately 760 billion renminbi, which is about 117 billion US dollars. And a lot of those would have been very small arbitrations. In 2024, there appears to be a 26% increase in the number of cases, arbitration cases, compared with 2023. Now, I don't know the number of those arbitration cases, but a 26% increase is huge. In 2024, the 5 of the largest arbitration commissions in China accepted 39,122 cases, with a total amount in dispute of approximately 609 billion renminbi. With respect to cross-border dispute resolution, arbitration commissions in mainland China accepted approximately 4,400 cross-border cases in 2024, with a total amount in dispute of approximately 200 billion renminbi. Almost all of those cases involved commercial disputes. And that's reflective of what we already know, which is China's huge trading network globally. Of course, China is also involved in disputes as a sovereign state, both within the structure of the WTO and in connection with other bilateral trade and investment treaties. And interestingly, China is becoming more active in that sector. Not so much the WTO for obvious reasons, but in relation to its BITs. So we talked about athletes in arbitration. China is really a legal athlete, if you like, because the current legal system has probably only some 35 years of history. And by that I mean a comprehensive system of laws, professional judges, and indeed law firms. When I first went to China, there were very few law firms, domestic Chinese law firms. There were far more foreign law firms. We know that the PRC operates a civil law legal system, and that system bears similarities to the legal systems of, for example, Japan and indeed Germany. One of the reasons German companies, I believe, do so well in China is because there is an alignment of legal cultures, which makes contracting in particular much easier. Harking back to the discussion on mediation, modern Chinese commercial culture favors mediation and, if necessary, arbitration of disputes. And its government policies to support mediation and arbitration. MedArb has been a feature in China and totally accepted for very many years, long before it became an issue, I believe, in the West. And we're still very cautious about MedArb, it seems, in the Nordic jurisdictions. The Chinese arbitration law itself was first promulgated quite late, even though arbitrations were taking place before then, in 1994, and it's been amended several times as it gradually comes into line with international arbitration norms. It is, in theory, based on the model law, and that you can see elements of the model law within it, but of course it's been adapted to suit the particular circumstances of the Chinese state. Unlike most legal jurisdictions, China does not have a single national arbitral institution. Instead, there's a complex network of provincial and municipal institutions, along with some specialized industry institutions, currently totaling, another statistic, 285 institutions as far as we can tell. That's a lot. For foreign companies, however, they will not, and I would venture to say should not, be involved with the majority of those institutions, which have very good domestic reasons, but they are not, they're not geared towards international disputes. We're actually sitting here, as history has recently been made. On September the 12th, the Standing Committee of the 14th National People's Congress voted to adopt amendments to the PRC arbitration law. And those amendments have taken several years to manifest, and in fact represent a compromise on many of the issues that have been discussed quite actively in China for a few years. And we now have a new law that will come into effect on March the 1st, 2026. The law is not yet available in English as far as I can tell, and it's certainly not available in Swedish. And I haven't, I'm afraid, managed to read it all in Chinese. But one of the things that is a little bit controversial, perhaps, is that it provides in a way that didn't exist previously for state participation in international arbitration or arbitration in general. And so we'll see what that means. At the moment, it's fairly generic language. China is, of course, a party to the 1958 New York Convention. It's got a couple of reservations on mutuality and so on. They're benign reservations, really. But it also has entered into a lot of bilateral agreements on arbitration and dispute resolution in general. And many of those bilateral agreements have been entered into in connection with the Belt and Road Initiative. And those bilateral arrangements supersede China's New York Convention arrangements, which is interesting. So who's done that? Singapore, Kazakhstan, Turkey, South Korea, Vietnam, Thailand, Russia, Bulgaria, Romania, the Ukraine, Poland, Bosnia and Herzegovina, Egypt, Morocco. Many countries are entering into bilateral arrangements with China, which is an interesting development.
If I can just jump in, is that for commercial arbitration or for investment, or both?
Investment arbitration is separate, so this is for commercial.
Okay.
Yeah. So they cover the ground effectively.
Yeah.
Yes. So just a few words on contracting in mainland China. I mean, this is an incredibly broad brush statement, and there will be exceptions, of course, but I think it's fair to say that parties from countries that operate civil law legal systems, and in particular Germany, and most likely Sweden as well, because there's a lot of successful Swedish businesses in mainland China, they're able to understand and navigate the contracting process in China much better, I believe, than parties from common law jurisdictions who have different expectations. From a legal perspective, one of those common law expectation issues revolves around the idea of an indemnity, which doesn't exist under PRC law. They just see as double dipping on damages. So force majeure is another area where you find differences in legal concepts. So can parties not use PRC law? It's actually mandatory for PRC law to be used between two contracting PRC entities. So that impacts foreign companies who have subsidiaries in mainland China because they are obliged with their Chinese counterparties to use PRC law. Again, that is not usually such an issue in countries like Germany, but it is sometimes an issue in the United States, for example. For cross-border contracts, invariably Chinese parties like to have their own law, PRC law, and there's a negotiation that takes place. Many of the leading law firms in mainland China, domestic Chinese law firms, are very proficient in certain legal jurisdictions now, mainly US jurisdictions. And so there's a lot more willingness to consider other governing laws and contract accordingly. So what tends to happen in a contracting situation, it's always been like this, is the parties fight over the governing law. They also fight over the dispute resolution clause and in the negotiation stage. And my advice has always been to give on the governing law because China's commercial laws are not that different to international laws, and to fight for the dispute resolution clause. And my advice is still that, I think, focus on the dispute resolution clause. So there's a sort of quid pro quo situation there. Invariably, with regard to mainland China, there's a lot of diligence on the part of foreign parties who are not familiar with China in particular, and learning that has to take place. And that is much more so than anything Nordic countries deal with amongst themselves. So what about dispute resolution? For foreign companies, the choice often is, do we use litigation or arbitration? Invariably, arbitration is favored because of its confidentiality, which applies within mainland as well. But there is a problem, potentially, and this situation is improving, if you end up inside mainland China on the arbitration track, because so far, at least, and we'll see what's in the new arbitration law, you cannot appeal those awards except on, and these are cross-border awards, except on very, very, very narrow grounds, and it pretty much never happens. So litigation, at least, especially if you are in one of the major cities such as Beijing or Shanghai, where foreign companies can get a proper hearing in terms that they would expect, litigation does provide the opportunity to appeal and to challenge and to go higher up in the hierarchy of courts, which can be very helpful. So you shouldn't, as a foreign company, dismiss litigation out of hand in mainland China. It's just a question of factoring in all the various elements that are at play.
Thank you very much, Susan. And I would just also be in the interest of time. No, it's so interesting, and I would have loved to listen the whole day. Unfortunately, time is running out. We have a couple of minutes left, so I just wanted to open up the floor. If there are any questions, we may have time for one or two. Are there any questions from the panel on what we have heard today, or any thoughts or reflections that you've had thus far?
I think it's quite healthy to actually acknowledge like the similarities as well. I think it's very interesting perspective with Swedish companies in China, for example. So yeah. I know we spoke before this panel as well, that sometimes the differences may be not exaggerated, but I think the practical aspect is super interesting to hear as well in this context. especially when you contrast the Nordics to China or the Nordics to common law jurisdictions. So.
Yes.
I also think it's very interesting to hear you say that you shouldn't rule out having disputes adjudicated before the Chinese courts, because I think that very much goes against sort of your just basic instincts coming from Scandinavia, because you would, No, but I would just anticipate that it would be very much of a home-biased system in terms of how the whole sort of political arena is structured.
Yeah.
Yeah.
So you've got a vast country. As a foreign company, you really want to be, if you're talking about courts, you really should only consider very few jurisdictions. And there are rules around whether or not you can use those jurisdictions. So Shanghai and Beijing are probably the ones that spring to mind immediately, but others are developing too. And there is an international court in China now, similar to Singapore. It will take some time to get up to speed, but there is an international court.
Yeah.
So the point actually I was going to make is the big decision for foreign companies is whether to go offshore with an arbitral institution such as the SEC, or whether to go onshore with a domestic institution, because foreign arbitral institutions cannot yet administer arbitrations in mainland China. And that's the big sort of question, which is probably another session.
We will definitely follow up with that. Any questions from the audience? Thoughts or yes, please. We'll have a mic from my colleague.
Hi, good morning. Knut Knudsen. I'm an independent arbitrator from Norway. Thank you for a very interesting discussion. I have lots of questions I want to ask, but I'll just do one, and that's to Elke. You were describing the active role that arbitrators play in Germany, and perhaps which is, I guess, influenced by the judges. And you also described this the preliminary assessment that the arbitrators provide. And I was wondering, would you then also see typically in the timetable for an arbitration that there would be a mediation or settlement window sort of put into the timetable to allow for the parties to consider the arbitrator's assessment and possibly then settle, as I understand that most companies in the end do prefer?
Thank you very much. So I need to emphasize that we make a huge difference between mediation and facilitating settlements. So mediation would never be done by the arbitrator. So if the parties wish so, they can have a mediation window, but I never experienced that, because once you started arbitration, you want to have arbitration and not delay the whole thing. If the parties consent to have and wish for such a settlement facilitation, that is reflected in the procedural calendar. And definitely I need to emphasize only with the consent of the party. So if you don't like that, you just say no, and that's it. No problem at all. You are not it gives not a bad feeling or anything. It's just your deliberate choice to say, well, we had this discussion so long, we now want to have an award. That's what we aim for. It's absolutely understandable and appreciated.
Thank you. Other questions? Yes, we'll give you the microphone.
Well, good morning, everyone. I'm Matias from Brazil, a current ICOL student. My question goes to the German practitioner. A few years ago, I undertook some research on comparative competence. And I read that Germany has a different approach to Article 2.3 of the New York Convention, in the sense that when a party tries to resist an arbitration, normally a judge would undertake a broader review of the clause or, of the facts in the case in order to assess whether the agreement is null and void, inoperative, or incapable of being performed. So I'd like to know if you agree with that, and how is it that operates in Germany? Because I read that it's not only prima facie verification, and that sometimes you can go very deep on that issue. Thank you.
Yes, Question to Elke.
Yeah, that is a very broad topic, and I feel that we need to discuss it later on. Anyhow, I realize that the concept of competence is very attracting to foreign law students. And what I can say is that we adopted the UNCITRAL model law, so I don't feel that there's really a different approach from elsewhere. And usually it doesn't place any problems.
Thank you for sharing that perspective. And some concluding remarks then from my side. Thank you so much to the panel for all your interesting point of views, perspective, for sharing the insights of the different jurisdictions. I will leave you with a few closing remarks. So from Susan here, we have heard many different factors when it comes to both mainland China and Hong Kong, but interestingly, fight for the dispute resolution clause, and you can then give the other side the governing law. That's something that you can bargain with, but fight for the dispute resolution clause. That's what I heard loudest and clearest. And from Germany, it's interesting to bear in mind that you can have a preliminary view from the arbitrators on a very, very early stage, which can both help in settlement discussions, but also for the council to realize how they can then, what they should focus on going forward to be successful in the arbitration. From the Swedish perspective, we heard that Swedes are positive when it comes to settlements, and that is something that can be considered already when drafting the contract, for example, including a mediation clause in the contract. And the Finnish perspective, Finnish companies are open to having Swedish law, the SEC, even Stockholm SSC, so it's nothing that's foreign. If you have negotiations with Finnish companies, maybe worth taking into consideration. And I'll leave you with this. Matthias Pippi Longstocking reference. If you feel sometimes I know nothing about this, surely I can do it. And with today's session, I hope that you have new insights and new tools for your upcoming contract negotiations. Thank you for coming.